Subscribe to both of my YouTube channels, Sharron WINBUSH and Goddess Sharron. Sharron is spelled with 2 R's. Turn on notifications, like the video, and most importantly, share the video with everyone that you know and share it globally. Thank you. This is 7 of 8 in the U.S. government versus RKELLY, the motion to acquit filed by Jennifer BONJEAN on February 17th, 2022. 10. Racketeering Act 12, Mann Act violation, Faith Rogers. The government charged defendant with 2 Mann Act violations in connection with Faith's trip to New York in May of 2017, alleging that defendant violated 18 U.S.C. 2421A and 2422A. The government charged that the defendant either transported or persuaded, induced, enticed, or coerced Faith to travel to New York with the purpose of knowingly exposing her to an infectious venereal disease under New York Public Health Law, Section 2307, and a reckless endangerment pursuant to New York's Penal Law, Section 120-20. The government failed to prove Mann Act violations under 2421A and 2422A, where it offered insufficient evidence that defendant transported Faith with the intent of exposing her to herpes, or to persuade, induce, entice, or coerce her to travel to New York with the intent of exposing her to herpes. Separately, the government failed to prove that defendant committed the offense of reckless endangerment or a violation New York Public Health Law Section 2307, which is unconstitutional in any event, both facially and as applied to the defendant. A. Intent. Because there was no link connection connecting defendant's transportation of Faith with an intent to expose her to herpes, defendant cannot be guilty of a Mann Act violation. As discussed at length, supra, the government must prove that the illegal sexual activity is the dominant, significant, or motivating purpose behind the transportation. See U.S. versus Kinslaw. Because the defendant's purported violation of the New York Public Health Law prohibiting him from exposing a partner to herpes was incidental to Faith's trip rather than a motivating purpose in transporting Faith, the intent requirement of the statute cannot be sustained. The government argued to the jury that it should find defendant guilty of a Mann Act violation by merely finding that defendant transported Faith to New York from her hometown in Texas for the purpose of sex. The only remaining issue is whether the sexual activity that he brought her here for was illegal, as it was R4433. This argument is legally flawed. Transporting Faith to New York to have sex would not satisfy the elements of a violation under Section 2421A, since the sex act itself was perfectly legal, as Faith was a consenting adult. The activity that was allegedly illegal in New York was exposing Faith to herpes. It is that act that must be motivating purpose behind defendant's transportation of Faith. Because the government cannot demonstrate a nexus between defendant's motivation for transporting Faith to New York and the illegal sexual activity, defendant must be acquitted of the 2421A offense. B. Coercion or enticement. The government alternatively argues that defendant is guilty of the Mann Act stemming from Faith's trip May 18, 2017 to New York because defendant knowingly persuaded, induced, enticed, or coerced Faith to travel to New York for the purpose of exposing her to herpes. Insufficient evidence exists to prove that defendant took any action to induce, persuade, entice, or coerce Faith into traveling to New York on May 18, 2017. The evidence shows that defendant invited a grown woman to meet him in New York, and she accepted. In March 2017, Faith attended one of the defendant's concerts in San Antonio, Texas with her sister. Faith had an opportunity to meet defendant at an after party backstage along with other individuals. Defendant and Faith had a conversation during the after party, and defendant provided her with his phone number. After the encounter, Faith and the defendant kept in touch via text and FaceTime. The conversations were normal, appropriate, and pleasant. Defendant complimented her appearance. Faith testified that defendant referred to himself as Daddy during those conversations. According to Faith, defendant asked to be called by Daddy, and she complied. Faith did not testify that defendant forced her to call him Daddy. Indeed, defendant and Faith had met exactly one time when Faith began calling him Daddy. On the issue of travel, Faith had this to say. Question. In your communications with the defendant, how, if at all, did the topic of traveling to see him come up? Faith. He had informed me that he was on tour right now, or, excuse me, at the time he was on tour. So he was just saying his schedule was kind of crazy. But whenever I wanted to come see him, I could. And he just said that he could arrange the days or just let him know when I wanted to come hang out. But that it would be fun. I would get to see, how it is, how he is on tour, things like that. Defendant told Faith that if she wanted to come to his shows, she could contact his assistant and he would arrange it for her. Faith then contacted defendant's assistant, who made travel arrangements for her. Originally, Faith was going to travel to Chicago, but ultimately traveled to New York for one of the defendant's performances. According to Faith, defendant informed her that he was having a show in New York and that he would like for her to come, hang out. It was going to be fun. So she said yes. Defendant's assistant arranged her travel, and Faith traveled to New York to attend the defendant's performance and hang out. No rational juror would conclude from Faith's testimony that defendant coerced or enticed her to travel to New York for the purpose of giving her herpes. By Faith's account, the defendant was polite, generous, and appropriate, leaving it entirely at her discretion to come to New York to attend his concert. Defendant's alleged bad behavior with other women is not sufficient evidence of this specific conduct in connection with Faith. On May 18, 2017, the government routinely asked the jury to find that it had proven elements of the charged offense simply because the defendant had, from the government's perspective, been controlling and coercive to other women. Faith's testimony does not establish any conduct on the part of the defendant that shows he did anything other than invite her to come to his concert in New York, an invitation she accepted. Frankly, if this conduct proves coercion or enticement by proof beyond reasonable doubt, the government is going to be very busy prosecuting Mann Act violations. Although it seems unlikely that the government has much of an intention of using this provision to prosecute influential, wealthy, white men who invite women on fancy trips for the purpose of engaging in sexual activity that those women later decide unpleasant. New York Health Law Section 2307 and Penal Law 120-20. To sustain the Mann Act violations charged in connection with Faith's travel to visit defendant in New York on February 2, 2018, the government must prove that defendant intended to engage in a sexual activity for which he could be charged with a criminal offense. Pushing the boundaries of its prosecutorial discretion, the government alleged that defendant could have been charged with a violation of New York Public Health Law 2307 and or reckless endangerment because he created a substantial risk of serious physical injury when he had unprotected sex with Faith, knowing he had herpes. At the outset, Faith did not contact genital herpes from defendant despite her misleading testimony. After returning from New York, Faith claimed she was diagnosed with herpes type 1 after getting cold sores on her mouth. Nearly 50% of the population has herpes type 1, and it cannot be contracted in any it can be contracted in any number of ways, including kissing, sharing a toothbrush, or eating utensils. Cold sores caused by herpes type 1 does not cause a substantial risk or serious physical injury. Presumably, even the government would concede this point. Furthermore, as a matter of law, unprotected sex with someone who has genital herpes does not establish a substantial risk of serious physical injury. According to the City Health Department, 1 in 4 New Yorkers has genital herpes. If sexual intercourse with individuals who merely carry the genital herpes virus carries the substantial risk of serious physical injury, New York City would have an astronomical hospitalization and death rate from the transmission of herpes. Although the government's expert witness identified some serious but unusual health risks associated with the contraction of genital herpes, the offense of reckless endangerment requires a showing of a substantial risk of serious physical injury. Serious physical injury is defined as a person's physical conditions that creates a substantial risk of death or serious and protracted impairment of health. The government did not satisfy this burden. The risk of defendant transmitting genital herpes to Faith is unknown, where he did not transmit it her, and there is no evidence that he was contagious or had an outbreak. If the government could show that defendant had active symptoms of herpes when he had intercourse with Faith, their proofs might be on a better footing. But merely having unprotected sex with someone who carries the virus cannot, as a matter of law, create a substantial risk of serious physical injury. Notably, the government cannot point to a single case that supports the prosecution's expansive reading of this statute. Even if the defendant had given Faith genital herpes, the government's evidence would be insufficient to sustain a charge of reckless endangerment. Herpes is not deadly and rarely causes any serious protracted health impairments. Again, the government's expert witness identified rare complications from herpes that could perhaps meet the definition under the reckless endangerment statute. But since those complications carry a low rather than substantial risk of serious physical injury as defined by the statute, the government cannot, as a matter of law, sustain this claim. Separately, the New York Public Health Law 2307 is unconstitutional facially and as applied for the reasons previously identified by defendant in his motion to strike allegations from count 1 of the superseding indictment and dismiss the remaining counts. Additionally, the statute is void of vagueness as it fails to put the public on notice of what conduct constitutes criminal behavior and authorizes arbitrary and discriminatory enforcement. 1 in 6 Americans, 1 in 4 New Yorkers suffer from genital herpes, herpes simplex 2. Under the plain reading of this statute, even a person who carries the virus but has been asymptomatic for decades would commit a crime by having sexual intercourse with another. In the absence of a definition of infected, the statute is unconstitutionally vague. While this court seems to assume that infected means having the virus rather than having the ability to transmit it, no authority supports this application, and such an interpretation would lead to arbitrary and discriminatory enforcement. 11. Racketeering Act 13, Forced Labor, Faith. No rational juror could conclude, based on the evidence adduced at trial, that defendant knowingly obtained or agreed to obtain any labor or services from Faith on January 13, 2018. A conviction of forced labor under 18 U.S.C. 1589 requires the government to prove beyond a reasonable doubt that the defendant obtained the labor or services of another person through inter alia threats of serious harm, and the defendant acted knowingly. The language "by means of" contained in the forced labor statute 18 U.S.C. 1589A requires the government to establish a causal link between the labor and services provided by the person and the threat of serious harm. Section 1589 is intended to address serious trafficking or cases where traffickers threaten harm to third persons, restrain their victims without physical violence or injury, or threaten dire consequences by means other than overt violence. The harm or threat of harm considered from the vantage point of a reasonable person in the place of the victim must be sufficiently serious to compel that person to remain in her condition of servitude when she otherwise would have left. Accordingly, the government on January 13, 2018, defendant violated the forced labor statute by using threats of violence to obtain labor, an act of oral sex from Faith. The forced labor statute was not intended to reach isolated conduct like that described by Faith. Faith testified that she traveled to Los Angeles to see the defendant, presumably to continue her romantic sexual relationship with the defendant. She described an incident where she and the defendant were in a small room in the Los Angeles studio where he worked. According to Faith, there was a gun in the room that made Faith intimidated, but defendant never touched the gun, never threatened her with it, or made any gestures that he intended to use it. Faith was simply uncomfortable by its presence. After an intense conversation during which Faith described defendant as being serious but not threatening, defendant directed her to give him oral sex and grabbed her neck before placing his penis inside her mouth. Without objection, Faith provided oral sex to defendant, although she testified that she did not want to. The forced labor statute was not enacted to remedy isolated occurrences like the one described by Faith. Indeed, it is not even clear from Faith's testimony that she gave any indication to defendant that she did not want to give him oral sex. Although she claims she did not want to give him oral, the record fails to reflect a causal link between the isolated act of oral sex and any threat of physical violence, even if Faith felt intimidated by being in the same room where a gun was located. This event did not amount to forced labor. Furthermore, Faith traveled to visit the defendant even after alleged act of forced labor, where she now claims she did not want to participate in the act of oral sex. 12. Racketeering Act 14, Mann Act violations, Faith. The government charged defendant with a second set of Mann Act violations in relation to Faith's second trip to New York on February 2, 2018. The government's evidence was insufficient for the same reasons argued in connection with racketeering. Act 11. First, the government simply fails to demonstrate that the defendant transported Faith to New York on February 2, 2018, for the purpose of exposing her to herpes. Second, the record is devoid of any testimony that the defendant coerced or enticed Faith to come to New York for the purpose of exposing her to herpes. Faith and defendant's so-called relationship was conducted almost entirely over text. After meeting at defendant's concert in San Antonio, Faith met the defendant face-to-face no more than 5 times. Faith always returned to her home in Texas after her short excursions to visit with defendant. This was a grown woman who made decisions to travel with defendant not out of fear, coercion, or any type of enticement, but because she wanted to. Faith herself refuses to identify as someone who was forced to do anything. On cross-examination, Faith admitted that she was not a victim and had made a choice to be with the defendant. Question to Faith. In one of the podcasts we spoke about this morning, the paper route, on that show you said during the interview, I don't like the word victim because I don't feel like I'm a victim. I'm a young woman, and let's be clear. I made a choice to be involved with that person. Do I feel like everything he did was right? Hell no. But I had a choice, and that's why I walked away. I did not move in with him. I did not live with him. I did not take any money from him. There is a choice that you have to make. You said what? And Faith responded, correct. Question, you made a choice. Faith, correct. Question, you're not a victim. Faith, correct. The record is devoid of evidence that proves that defendant coerced or enticed Faith to travel to New York on February 2018. The government must point to some specific words or conduct by the defendant that were coercive or enticing in respect to Faith. An invitation is simply not enough. Accordingly, the government failed to prove Racketeering Act 14. In sum, the government failed to prove the defendant guilty of RICO. 2. The government failed to prove counts 2 through 9 of the indictment. The government charged defendant with 4 freestanding Mann Act charges that mirror Racketeering Acts 8 and 9 related to Jane. For the reasons argued supra, pages 29 to 42, the government failed to prove counts 2 through 5 of the indictment. Similarly, the government charged defendant with 4 freestanding Mann Act violations that mirror Racketeering Acts 12 and 14. For the reasons argued supra, pages 47 to 53 and 55 to 56, the government failed to prove counts 6 through 9 of the indictment. The Mute R. Kelly campaign stopped the flow of R. Kelly's income. Sony releasing him hemorrhaged him financially. His inability to tour. He had back taxes because of poor management and accounting that the government seized assets for that. And then he had back child support. He's been not in a position to hire the top-notch legal team necessary to get through this entire case, which is why he was compromised in the New York case. He needs all his fans, supporters, or anyone who wants to help to send money directly to him, not through a third party, because he has an upcoming Chicago case and he must have great legal representation to defend himself to the best of his ability. Mr. Kelly is fighting a case in Chicago, and he needs all of the assistance that anyone can give from all of his fans and supporters around the world. There are 3 ways that you can get money to Mr. Kelly. 1, you can send money via Western Union. That's for $300 or less. That will get to him fast. Or you can go to the BOP.gov website and send money via credit card. Those are the fastest ways to get it to him. Or you can mail a money order to him to P.O. Box 474701, Des Moines, Iowa, 50947-0001. It will go directly to Mr. Kelly, no third party, no one in between, and he will have a record of who sent what amount, and from where it was sent. So it is your way to directly help, directly impact, to directly put your hands on R. Kelly and show him that you love him, show that his fans from around the world are supporting him and they want to assist him in fighting for his freedom.